Good morning. Court is now officially in session. My name is Jim Edwards. I'll be the presiding judge. We have Judge John McIver and Judge Rand Wallace also on the panel. If you have your cell phones handy, turn the ringer off, please, so it doesn't interrupt your brilliant arguments, so that we can hear every last word you say. It's always helpful if you're not the one speaking to mute your microphone. Sometimes we get a little feedback, but if we see we're have only moving lips and no sound, we'll alert you pretty quickly so that you can get back on. For appellant, typically we reserve 5 minutes for rebuttal. If you want something other than that, just let us know. You've got a clock there. That's the full 20 minutes you get, and you don't get 5 minutes in addition to the 20. The yellow light will come on. Sometimes it's hard to see. If I see you're getting into your rebuttal time, I will let you know. The case we have now before us is case 22-2188, Robert and Carrie Sanchez versus Volusia County, Florida. And if counsel's ready to proceed for appellant, you may go forward.
Thank you. Good morning, Judge and judges. Good morning, Mr. Brown. May it please the court, my name is Ron Hertel on behalf of the appellants, Robert and Carrie Sanchez. We're here on an appeal of an order denying a motion to reinstate a set-off affirmative defense and to vacate a final judgment. This case was on a prior appeal where the lower court had dismissed with prejudice all of the affirmative defenses and all of the counterclaims made by my clients. In that first appeal, this court reversed on 5 of the counterclaims, and one of the defenses. However, we did not seek review of the set-off affirmative defense because that defense was stricken for mootness. That was the only reason, and that was based on the judge having prior dismissed with prejudice all of the counterclaims. Obviously, if the counterclaim survived, that set-off defense could not be stricken for mootness. But when ruling, the lower court specifically stated, quoting from the order, it says the 4th affirmative defense asserting defendant's right to a set-off as a result of their anticipated to be successful counterclaims is stricken as moot because the counterclaim was dismissed with prejudice. However, this set-off—
This is for the earlier appeal, correct?
Well, we did not appeal the court's ruling as to this set-off defense because of the sentence I'm about to read. When it said it was stricken as moot, it continued and said, however, this set-off defense will be reinstated in the event that any portion of the now dismissed counterclaim should be reinstated after the appeal.
Okay, right now, I want to be very clear. The order you're appealing is found in the record at pages 740 and 741, correct? The order denying defendant's motion to vacate, order granting summary judgment and final judgment, correct?
That's correct, yes.
All right, and in that particular order, is there a ruling on your motion to reinstate that affirmative defense of set-off?
The court actually ignored it completely.
So, and that's what I'm asking you. There was no ruling on that, correct?
Yes, but it refused to vacate the summary judgment, which in effect is a denial of the motion to reinstate the defense, because the summary judgment, in order to be granted summary judgment, the moving party has to negate each and every affirmative defense or prove that it's legally insufficient.
Is that still the law under the new rule?
That is the law as far— I don't believe that has been disturbed at all. My understanding under the new rule is that it just changed the standard of proof to be more like a directed verdict instead of granting summary just based on any issue of material fact. Now it is, can a reasonable juror side with one side's argument, which has lightened the load for the movement for proof. But this was not granted based on any sort of evidence or proof or anything. It was— they just said, the court said that the affirmative defense was moot. There's no set off without a counterclaim. And then when this court, your court, reinstated 5 counterclaims, that set-off defense should have revived. So the summary judgment was basically built on a foundation of sand that the defenses will not revive. Had no counterclaim been reinstated by the appellate court, then there would be no set-off defense. But that's
Mr.
not what
Rattell,
occurred. Yes.
Just help me with the record really quick. Prior to the summary judgment, what happened with your motion to reinstate the set-off? Was there a written denial of that, or was it just ignored in the summary judgment and it hasn't been dealt with?
The summary judgment itself was entered about 2-3 years ago. And that was based on there being no affirmative defenses that would preclude summary judgment. My issue is that now that
In other words, what I'm asking is, did you have a lingering motion to reinstate the set-off that was never answered?
prior to the first appeal, no, because the court already said it would reinstate the defense. So I wasn't seeking to say that the lower court made a mistake by saying it would reinstate the defense. I left it as is and trusted that the trial court judge would do what he unambiguously said he would, which is reinstate the defense. Mm-hmm.
My concern or my question really is, in your motion to vacate the summary judgment and reinstate your affirmative defense, you specifically asked to have the set-off affirmative defense reinstated, correct?
Correct, yes.
And the court never ruled on that part of your motion, did it?
I think it did without saying it, because if it's going to refuse
Well,
to...
it did not grant or deny that motion, that part of the relief, did it?
The order itself, hold on, let me pull it up here. I apologize.
740, 741.
Okay. Sorry, just bear with me. I didn't have it pulled up. Here we go. Okay, 740. Okay, so
There? Okay.
it says that the court finds no merit to the defendant's argument. That's all it basically says. And then after that, just denies the motion to vacate, stating that that was left undisturbed on appeal.
That the motion for summary, that the summary judgment itself was left undisturbed.
That is correct,
Okay.
because
But in your motion, you made the specific motion in that multi-titled motion to reinstate the set-off affirmative defense.
correct.
Where in this order being appealed does the court address that motion to
I would-
reinstate the set-off?
All I can state is what I've already stated, which is that, yeah, the court just says it finds no merit to our argument. And it left it at that. It doesn't include the word affirmative defense at all. It just says what in the title it says, though, order denying defendant's motion to vacate, order granting summary judgment and final judgment of foreclosure, and order show cause. So as to the affirmative defense, it doesn't specifically state the affirmative defense, but the effect of not addressing the affirmative defense while refusing to vacate the final summary judgment is that it's basically disregarding that defense should persist. The judge basically did nothing with it. He said it. He said the final summary judgment is going to stand, and then he actually ordered the sale of the property without my client's ability to even try to negate the foreclosure of their unique parcel of property without asserting their counterclaim and set-offs, which could entirely negate the loss of their property. So
Right. No, I understand that, but in paragraph 10 of your motion, and that's found at record 697, if you want to take a second to get there, I'm looking at paragraph 10 that's on that page.
yes.
Okay, you have things broken down, one to set aside the motion for the summary judgment. And then that particular paragraph 10 there says the Sanchez's move for the court to reinstate the affirmative defense of set off since their counterclaim has been reinstated on appeal. Now, nowhere is that motion ruled on. That particular aspect is not even mentioned. It's the judge is going, your motion to set aside the final summary judgment, you appealed that and the Court of Appeal didn't do anything. It didn't reverse that. It didn't set it aside. It didn't quash it. So I'm leaving that alone and we're setting the case for trial. And it ignored, I think as you said in your brief, it ignored that portion of your motion that requested the reinstatement of the set-off defense, didn't it?
That is correct. It ignored my portion of my motion. Yes.
Well, then it didn't grant or deny it.
But this is they are so intertwined that I don't see how you can address one without seeing that the other has been effectively denied. Because if the set-off is reinstated, the summary judgment has to be vacated. The judge
But
just
the Court of Appeal didn't vacate it.
No, because I never asked the Court of Appeal to disturb the judge's pronouncement that he would reinstate the set-off defense, and then he effectively reneged, and we detrimentally relied on what the judge told us, that he's going to reinstate a set-off defense. Well, it doesn't make sense to reinstate the defense without also vacating the summary judgment. So
did you move for rehearing to get the judge to specifically rule on your request to reinstate the set-off defense?
My motion to rehear is in here. I would just have to find it. Hold on.
I'll tell you what, why don't you, while your opposing counsel's arguing, you can find that and we can talk about it on rebuttal.
Very good.
You've got it right there. You got it?
No, that's fine.
Okay. All right, go ahead. Sorry to interrupt you.
No, Mr. Brown can proceed. I think that's a good idea.
All right, you're going to reserve the rest of your time for rebuttal?
Sure, yes.
Okay. Mr. Brown, you're up.
May it please the court, your honors, I'm Russ Brown on behalf of the appellee, County of Volusia. As the court has indicated, this is a case, or as Mr. Hurdle, good morning as well. It's nice to see you again, Ron. As Ron has indicated, this here is before you for the defendant's motion to grant summary judgment and final judgment of foreclosure in order to show cause. This case has been before this court now 2 times. There was actually a prior case, 5D20-2109, where the appellants had previously moved for what was then determined to be a non-final order, which is why the court issued a show cause, finding that the counterclaims were compulsory with the underlying action, which is foreclosure actions in this case, to foreclose liens after code enforcement violations were brought and the process went forward. And the second appeal that the court was mentioning earlier, that was case number 5D21-209. That is the case that was before the court about 1.5 years ago, approximately, where the court did not overturn the summary judgment, as Judge Edwards mentioned, and indicated, though, that the appellants should get one more bite at the apple, if you will, to state causes of actions for 1983, and then said that they had sufficiently pled a cause of action for trespass. So the order went back down, and the trial court, as Mr. Hurdle said, had us file our motions, and then made actually the notice to move the case for a sale for the foreclosure sale, if you will. And at that point, there were some continuing interactions between the parties trying to come up with a global settlement. And then Mr. Hurdle, as he mentioned in the case, had asked the judge to reinstate, based on the previous order that was that before in the case 5D21-209, to reinstate the affirmative defense of set-off. And the judge effectively, as Mr. Hurdle mentioned, we're here today because the judge denied the defendant's motion to vacate the granting of summary judgment, a final judgment of foreclosure in the order to show cause. So the county is relying upon the fact in this case that do not believe that this is a final order by the judge. I believe it's a non-final order. An order is considered final for appeal if it disposes of an action on its merits, leaving no question open for judicial interpretation except for enforcement of a decree. And that's from 440 Ibis Circle LLC versus JP Morgan Chase Bank et al. That can be found at 193 Southern 3rd, 957, 50 CA case from 2016, which just merely recited the ongoing Supreme Court precedent about compulsory counterclaims. And which is notable that in the Supreme Court case, SLT Warehouse Company versus Webb, a 1974 case at 304 Southern 2nd 97, about that same time, the second DCA in 1974 at 301 Southern 2nd 21 was deciding Tausig versus Insurance Company of North America, where it stated that a case involving a claim and a compulsory counterclaim, no appeal can be taken until disposition of both claims and counterclaim. So in this case, what we have before, it's still down at the trial court, is the counterclaims are essentially reinstated. They're pending before the trial court right now. In fact, the order in front of the court right now that's up for decision today indicates that the trial court will be, the second amended counterclaim will be set for jury trial by separate order. So there are pending counterclaims still pending in the court, regardless of the underlying claim, which are intertwined. They're compulsory as previously determined by this court in case number 5D20-2109. Alternatively, though, I would argue that if the court finds that this is that this is a final order for appeal, that the trial court did not abuse its discretion in denying the appellant's motions, as the essential essence of appellant's affirmative defense still remains in the court below to be decided. So there's a case that's similar to this in Venus Laboratories Inc. versus Katz at 601 Southern 2nd 630. It's a third DCA 1992 case that where the court did not allow Venus to amend its answer to assertive counterclaim. Third DCA found, now what's notable about a lot of these cases is that a lot of these cases are everything's wrapped up. It's an actual final order on the final judgment. So the court was determining whether any error was committed, and they determined it was harmless error because the essential, the essence of the affirmative defense that was not allowed to be asserted was asserted in a counterclaim. And so essentially there was no error. So that's a similar situation here, is that, so we have this foreclosure order by the judge, but there are counterclaims that are compulsory that still penned in the court below, that the court could craft a number of decisions at its discretion before we get a final order, a final judgment for the case in its entirety. So it's premature, in the county's opinion, to at this point for the court to rule on what is a non-final order.
If I can ask you this,
Yes, Jeff.
doesn't this appeal just boil down to appealing an order refusing to reinstate a defense?
It does, Your Honor.
All right,
Yeah,
is
I think that's
is that one of the listed orders that can be appealed as a non-final order? Just, assuming and giving credit that the motion was actually ruled on, which I'm certainly not seeing, but assuming it was, and the trial judge said, no, I'm not going to reinstate that defense. Wouldn't that normally then you go to trial without the defense and you would take that up as a final appeal? You don't have the right to take that up as a non-final appeal, do you?
I don't believe so. No, Your Honor. I think the case law is that it has to be a part of a final appeal, essentially at once everything's wrapped up, because the court still has a lot of discretion. Even if they say a set-off is not affirmative defense, the court has a lot of discretion with the claim and the counterclaim as to how they're going to craft the final judgment based on one versus the other. So yes, I think the court is correct that the judge didn't technically rule on the request to reinstate the affirmative defense. It was kind of a de facto ruling, if you will, that resulted in where we are here today. But even if he had or hadn't, don't think this is I don't think this is a final order. It's a non-final order that is not properly before the court at this time, and there's still a lot that the trial court can do, especially with the counterclaims pending.
Right. As of right now, the summary judgment and final summary judgment, that was on the county's claim to foreclose the code enforcement liens, correct?
Yes, Judge.
And that was left undisturbed on appeal,
Yes, Judge. Based on
which is what the trial judge says here, and the trial judge is correct in that. It was not disturbed, it was not quashed, set aside, vacated, touched, right?
not the way I read the order from 5D21-209, correct, Your Honor?
Okay. And so really at this point, but for the appeal, there would be a trial going on regarding the counterclaims that the Sanchez's filed claiming trespass in 1983 and whatever else, correct?
Yes, sir.
All right. And what the judge did, if the judge did anything, was to say, I'm not going to reinstate that affirmative defense of set off. Period. And is that an appealable final order?
No, Judge, I don't think it is at that point in the case. I don't.
And it's not a non-final order in the list under the rule either, is it?
No, sir, I guess not, because but is the essence of the affirmative set off with the counterclaim still pending is still a part of the case. So if the counterclaims are compulsory with the underlying claim, then the essence of the set off is still there. So yes, it's not it's a non-final order that's not appealable at this point. And it would be similar to once we get to the end of the case, if you will, Your Honor, from everything being decided. At that point, if it wasn't addressed by the court, it could be appealed at that point, I would think, at the end of the case as a final order.
Right.
And so,
And Mr. Brown, just to complete that thought, it would be the set off would be appropriate to be addressed by the judge at the end of that trial, unless the effect of the set off is cured with regard to an award, whatever monetary award results at the end of the trial, correct?
Yes, sir. I think that's correct, Judge.
It is correct that there was no hearing on that question, though, correct?
I'm sorry, Your Honor, which question?
On whether or not the set off would be remedied in the counterclaims case.
Yes, there's been no hearing on that. Yes, Judge. It's all been written and determined in written orders. There's been no hearing.
Okay.
And so I think with that, Your Honor, I don't, unless you have any more questions for me, I'll cede the rest of my time.
All right. Unless my colleagues do, and they don't appear to, we're back to you, appellant, to take it up from there. You've got a little bit more than 9 minutes for rebuttal.
Thank you, Judge. Just to start, the Venus case referred to by Mr. Brown, he actually had the holding reversed in that case. It wasn't that there was no error because the affirmative defense was not allowed to be reinstated. The court found no error because the appellant sought to have his counterclaim reinstated, but his set-off defense still persisted. So they said there was a harmless error because the set-off affirmative defense, in effect, maintains their right to seek damages back against the plaintiff in that case. Now, in this case, we have the exact opposite. I've got a foreclosure order and a judge who is trying to set the sale before this case is completely at the end. And my client's property will be sold because there's no defense to prevent that from happening. Counterclaims and affirmative defenses are not treated the same way under the law. I mean, statutes of limitations don't apply to affirmative defenses. One of the cases we actually looked at that was cited in my brief, the Pavolini versus Williams case, even discusses how statutes that may be barred as a claim would not be barred as counterclaims. So, I mean, they're not on the exact same thing, and they're not treated the same way under the law. With respect to whether this is a final order or not, we sought review under 911 OK. which allows review of partial final judgments. And the effect of the judge's ruling to refuse to set aside his final judgment, even though the set-off was wrongfully dismissed as moot to begin with, that in effect has damaged my client because it's been denied the right to the due process right to be heard and to prevent the sale of their property before it even gets to the end of the road.
Well,
So
but you,
if this-
you already, I'm sorry, you already appealed the summary final judgment in the previous case before our
No.
court.
No, I didn't actually. That's what the issue is. I had sought to have my counterclaims reinstated and to have one affirmative defense for unclean hands ruled upon. The 5th DCA did not set aside the set-off defense. And the reason I didn't seek review of the set-off defense was because the court already stated it was going to reinstate the affirmative defense if the counterclaims revived. So,
Well, counsel, I'm looking at the opinion as set forth in the Southern Reporter
Mhm.
at 331 Southern 3rd, 853. And our court starts out with appellants Robert J. Sanchez and Carrie Sanchez appeal the final summary judgment entered in favor of appellee, the county of Volusia, that foreclosed code enforcement liens and so on. So the opinion of this court was that you were appealing the final summary judgment. So you've appealed the entry of that. That's been appealed. That was not overturned. That was left alone, just as the trial judge says. Now you're saying somehow you have a right to appeal that once again. I don't understand where that springs from.
Sure. Looking at the same case you are, Judge, the third sentence, it says, first, my clients argue that the trial court erred in striking their first affirmative defense with prejudice. That was all that was review that was sought. Second, appellants assert that the court should not have dismissed their amended counterclaim with prejudice. So to the first issue, the affirmative defense as to unclean hands, we did think that the trial court got it wrong. And so we sought review of that. But we think the trial court was exactly right in its fourth affirmative defense. We didn't seek review of that because the court said it would reinstate the defense. And we relied on that. You know,
So you raised two issues in that first appeal. One was striking the first affirmative defense, which this opinion, the prior opinion says, we affirm that without further discussion. The next thing is about the counterclaim, and the opinion says reinstate the counter or give them another chance to plead to counterclaims. Looks like they've got enough here, at least for the trespass claim. So don't dismiss it with prejudice, give them another shot. But as far as the final summary judgment that was entered in favor of the county, you didn't appeal that according to the opinion and according to the issues raised. You didn't say that the trial court got it wrong in granting summary judgment. So now you're saying you're trying to appeal that same final summary judgment again as a final order.
Well, only to the extent that the lower court stated before the first appeal ever happened that set off defense would revive if we won on appeal, and we did. And then how can you have a summary judgment that's predicated on an affirmative defense that is not moot? So it just
so
doesn't
what
make
you
any
now,
sense.
but again, counsel, what I asked your opposing counsel, you're now appealing if the court ruled on it. I'm not convinced they did, but if the trial court ruled on it, it's a motion striking or not reinstating a defense. How is that appealable under any rule? It's not in the list of non-final orders under 9.130. It's not a final order. Yep. I mean, why shouldn't you have to wait till the end of the case after the counterclaims are tried and the judgment's entered on them?
Because the property will be gone by then, Judge. It's just the way Judge Rowe has been handling this. He wants the property sold before the case is over.
Have you moved for stay?
We ruled for, well, we've asked for stay, I think 3 times in this, and so far the court is now stayed it. But we also saw it in our reply brief citing to the Mahoney versus Rights Healthcare and Rehabilitation Center case, 194 South Third, 399, where those appellants sought review of a final order, but instead treated the review as under a grant of a petition for certiorari. And so in our reply brief, we also sought certiorari review because it meets all the elements. There's a departure from the essential requirements of law because my client's property is going to be sold on valid set-off when there's a valid set-off defense. A valid set-off defense precludes summary judgment. Those cases are very clear. But now
You raised certiorari for the first time in your reply brief, is that correct?
I did. So what we did there is, again, I'm relying on this case that I just cited to, the Mahoney case, which is second DCA case from 2016, where the court basically disregarded it as a final order, but treated it as a petition for certiorari. And then it ultimately denied the writ of certiorari, but it granted certiorari review because there was a departure, because it met, at least on its face, the elements of the departure of the essential requirements of law, resulting in material injury for the remainder of the trial that cannot be corrected on post-judgment appeal. That's exactly what we have going on here. And what my argument is that if this piece of property, this unique piece of land is sold, and then my clients prevail on counterclaims, we have to remember these counterclaims are asserted against a government entity with a $200,000 cap on tort damages. That's not going to completely negate my client's ability to stop the sale. But on my 1983 claim, should they survive and they go to trial and we win, we would have the right to negate the entirety of the amount, because based on constitutional violations, the courts have to seek to basically do justice, and the trial court can completely negate the judgment liens, and then my clients don't lose their property. And in the end of the day, my clients, by winning, they would have the right to keep their land, versus they get a judgment for $200,000. That's not the value of the property. There's no way to compensate them for that injury.
Right, and it looks like you're out of time. Counsel, Thank you very much, and we will be in recess.
Thank you.
Thank you, Judge.